So what happens when a pretty simple business loan goes wrong? I mean, really wrong. So wrong that it kicks off a legal fight that lasts for 35 years, goes all the way to the Supreme Court, and honestly threatens to shake up the entire banking industry. Today, we are diving into one of the longest, most complicated commercial disputes in Kenyan history.
Okay, let's get into it. And just look at this timeline for a second. It really shows you how epic this whole journey was. It all kicks off with a straightforward loan way back in 1982, but the final, absolute last word on the matter doesn't come until 2025. That is a 35-year legal saga. So to really get how this all went so sideways, we've got to go back, way back to the very beginning, to the original deal between a clothing company, Manchester Outfitters, and Standard Chartered Bank.
Now, on the surface, this was a pretty standard international finance deal for the time. It basically had three moving parts. First, the bank's London office lends money in a couple of foreign currencies. Second, the bank's Kenyan office guarantees that loan, saying, hey, if they don't pay, we will. And third, the borrower puts up its property as security to back up that guarantee. Seems simple enough, right?
Okay, let's zoom in on this one word, debenture. Because it's super important. You can think of it like a master key that the bank holds over a company's assets. And this one piece of paper, signed way back in 1982, would become the star witness in a massive, multi-billion shilling fight decades down the road.
So for about 4 years, everything was chugging along just fine. But then, in 1986, they decided to change the deal. And this one change, which was actually meant to make things simpler, is what lit the fuse on a 35-year legal explosion.
You see, to get rid of all the headaches that come with changing foreign currency rates, both sides agreed to just convert the whole thing into Kenya shillings. The local Kenyan bank basically bought the debt from its own London office. It was a practical move, but this little simplification, it ended up creating a huge, unexpected mess.
And this is where the whole thing splits in two. The bank's argument was, look, that original debenture from 1982 is a continuing security. It's like a running tab that covers any money you owe us until we formally cancel it. But the borrower came back and said, no way. That 1986 agreement was a totally new deal. It wiped the slate clean and needed its own brand new security, which, by the way, we never gave you.
And here it is. This one little clause, tucked away in that new 1986 agreement, was the borrower's entire case. This was their smoking gun. They argued that this sentence supersedes any previous agreements, meant that the old 1982 debenture was just gone. Poof, vanished. So let's head to the courtroom and see how that one clause led two different high-level courts to reach completely opposite conclusions. I mean, it created a legal roller coaster that caused some serious confusion in the banking world.
All right, first stop on this wild ride was the High Court. After years and years of arguing back and forth, they finally made a decision in 1999.
And the High Court judge came down firmly on the side of the bank. The ruling was clear that original security was a continuing one. It was never officially canceled, so it was still very much valid. The borrower had to pay up. Now, for the next 2 decades, that was pretty much the final word. But of course, the case was appealed. And then, in 2022, more than 20 years after that first ruling, the Court of Appeal looked at the exact same set of facts and saw something completely different.
In a decision that was a total bombshell, the appellate court said the borrower wins. They zeroed in on that supersedes clause, saying it canceled everything that came before it. And since no new security was put in place for that 1986 loan, the bank basically had no leg to stand on. This decision sent absolute shockwaves through Kenya's entire financial industry.
So now you've got total chaos, right? The High Court says one thing, the Court of Appeals says the exact opposite. The whole mess had to go to the Supreme Court to settle it, once and for all. And they boiled it all down to 2 critical, make-or-break questions that would basically set the rules for lending in the country from now on.
So question number 1 was this. Does a bank have to go through all the paperwork of creating and registering a new security document every single time a loan is tweaked or a new bit of cash is advanced, even if there's already a security on the books?
And the Supreme Court's answer was a loud and clear no. They powerfully backed up this idea of a continuing security. Think about it like a gym membership. You don't get a new card every time you walk in the door. Your original card works for every visit until you go through the official process of canceling your membership. Same idea here.
And that's the absolute key. The court made it crystal clear. You can't just assume a security is canceled.
There's a specific legal process for that. You have to file a document called a memorandum of satisfaction. Since that never, ever happened in this case, that original 1982 debenture was still legally alive and kicking.
Okay, so that settled the security question. But then the court moved on to an even more basic, fundamental question. Let's just pretend for a second that the security wasn't valid. Does that mean the borrower just gets to keep all the money, no questions asked? Here again, the court was absolutely blunt. The loan agreement and the security are two separate things. The basic duty to pay back money you borrowed exists whether or not you put up property to secure it. At the end of the day, a debt is a debt, period.
And they explained why, using a core legal idea called unjust enrichment. It would just be fundamentally unfair to let someone get millions of shillings, never pay it back, and get their property back free and clear. As the old saying goes, you just can't have your cake and eat it too.
So, after this unbelievable 35-year journey, what's the big takeaway? Why should any of us care about this one case and its ripple effects on banking and business? Well, the impact is actually huge. This Supreme Court decision brought some much-needed stability and certainty back to the whole financial system. It confirmed that banking practices that have been around for ages are in fact legally solid. It protects lenders from a nightmare of paperwork, and most importantly, it hammered home that simple core principle: a debt is a debt, and it has to be repaid.
And so, the Supreme Court's final word brings this marathon 35-year battle to an end. It definitely provides clarity for both lenders and borrowers, but it does leave us with one last thing to think about. In making things more stable and strengthening the hand of the banks, does a ruling like this strike the perfect balance? Or does it maybe tip the scales of power a little too far in one direction? Something to chew on.